This will be the first of the series of administrative law lectures in continuation from the place we stopped our classes due to the lockdown. Now, it is a request that whatever we have studied in the lectures during regular classes, please revise those, and then only you will be able to understand the rest of the lectures, including these online lectures. I will be discussing the cases with the theory behind and the reason given for these decisions. So, as a flashback, I would like to tell you that we have studied in detail as to what is separation of powers, and we have also discussed that we follow the flexible version of the separation of powers. Okay, now briefing the theory because it is important for the rest of the lecture. Now, under the theory of separation of powers, we have majorly three organs of the government, and they are legislative, executive, and the judiciary. Now, the reason behind the separation between the three organs was one word which I always refer to is the word said or stated by Locke. He said, the tendency of human to grab power is a frailty, is a weakness. Therefore, concentration of power on a single individual shall not be made. Therefore, the powers have to be separated from each of the organs. However, we also studied that we do not follow the stricter version of the separation of powers. Now, one argument was given by Justice Cardozo that any rule under the separation of powers does not have to be necessarily obeyed in its pedantic vigor, and certain assumptions of powers between the organs shall be allowed. So, assumption of power. So, the legislature will assume the power of the executive and also the judiciary. The judiciary can also assume the power of the executive and of the legislature, and the executive can assume the power of the legislature and also the judiciary in certain areas and aspects. Therefore, the concept which came up was when the legislature provides its one of the powers to legislate to the executive. We called it delegated legislation. The reason behind the delegation was that in areas which require knowledges of precision and also requires constant supervision, it would not be right for the legislature to be presumed that they always possess the knowledges of precision, and also they will not be able to supervise those laws which they have made. Therefore, certain aspects of law are delegated to the executive for the purposes of inclusion of knowledges of precision and also close supervision. Now, when such a delegation takes place, what is again to be remembered is that in a country like ours, the legislature is not a sovereign. We have discussed this in the earlier cases. It is, in a sense, a limited sovereign. It means they do not possess wholesome powers in the areas of lawmaking because they have certain limitations, and one of the limitation is the fundamental rights provided under the Constitution of India. Therefore, if any delegation is to be taking place either from the legislature to the executive or a sub delegation of the powers of the executive to officers of administration, all of these powers will be having those limitations to which the lawmaking power of the legislature is subject to. To whatever we discussed in this video, some additional points also have to be taken into consideration, and that is when there is a delegation, when there is a delegation of legislative function, then we read that there has to be a control, and that control has to be of two different types. One is the control of the legislation, and the other is the control of the agency which is delegated the legislative function. So it was learned that it is not only enough that the agency is regulated, but it's also required that the legislation is also regulated by the central legislation. Now, in regulation of agency, I had earlier discussed, for example, appointment, removal, salary of the officers which are members of or to become who are to become the members of the subordinate authority. Such aspects, if they are controlled, then it is the control of the agency. Now, control of legislation, we discussed one of the requirements as to legislative control, which is the requirement of laying. Now, from both these two, we find the reason that even when the legislative function is delegated, there are controls which have to be made into the legislation and also something which are external to the legislation. In these delegated legislations also, for example, you have heard that the president is having certain discretions, the governor is having certain discretions, and they have been provided under the constitution. Similarly, the officers who are to administer are also provided certain discretionary powers. Now, if you remember Dicey, he said that wherever there is a discretionary power, there is a arbitrariness. involved, because discretion is application of mind, and the officers responsible for applying the discretion will be having the same human frailty and then exercise that discretion in its own benefit. However, the logic now prevailing is that such discretionary powers are not always arbitrary. If such discretions are applied reasonably, then those application of minds can be differentiated from the discretionary application of minds. So now we know that there is separation of powers and there is delegation of legislation by the legislature to the executive. Now, in cases of delegation, there are also instances of discretion, and this therefore becomes one of the topics for our discussion. Now, such discretion has also to be limited. If legislative power is not unlimited, the executive power is not unlimited, then obviously administrative discretion will also not be unlimited but limited. Now, what are the limitations? We'll come to know that slowly. But first, if I ask you, if the central legislature has given power under an act to the state legislature to pass orders for regulating something which is known as essential commodities. Now, this is very important for the times we are facing, that is corona, as to different commodities are scarce commodities, and there is an urgent need for every of those commodities, and people are raising up the prices for gaining their own personal benefits. So, in order to regulate the pricing, marketing of these products, there is a central act which is the Essential Commodities Act. Under that act, the state governments can also pass orders for regulation of certain commodities. If the Central Act provides powers to the state legislature through which the state government can pass orders for regulation of essential commodities. Now, in such an order, two main things are regulated. One is on the people on whom it will apply, and also the power of granting and revoking licenses. So the essential commodities has only to be regulated by making only those persons enter into the market of selling and purchase by licenses and permits. Now, in this particular order, it will be necessary, because it is an essential commodity, to give certain discretionary powers to the officers working in this particular area. Popularly said that if such delegation and discretion is not given or not provided to certain authorities, then it will stop the wheels of the government. This has also been discussed in one of the case. Therefore, so in this particular case, which is Dwarka Prasad Laxmi Narayan versus State of UP, the particular provision which gave discretionary powers to the controller of the specific essential commodity is challenged on the grounds of arbitrariness. State of UP passes a or notifies a Uttar Pradesh Control Order of 1953, in which mainly, to be in brief, it regulates the market of coal. Now, there are two main provisions which are important to be discussed in this case is the object of the order. The object of the order is that no person shall stock, sell, or store for sale or utilize coal for burning bricks except under the license. Now, there are people who will be exempted from license. For that, see 2A. Now, one of the exemption is when it relates to own consumption. So, this is a reasonable provision for their own consumption. There should not be any problem. But the problem is in the clause B, where it says that nothing in the order will apply to any person or class of persons because they are exempted from the provisions. By whom? By the state coal controller. So the state controller, coal controller, is having the power to exempt any person or class of persons. Secondly, the licensing authority, the powers are to refuse, to grant, to renew, cancel, suspend, revoke, modify licenses. Now, this power of the licensing authority is also provided to the state coal controller. One important thing is that if any license is revoked, cancelled, modified, suspended, then reasons for such action is to be recorded. Further, the state coal controller can also authorize any other person to work for his behalf, to work on his behalf. Now, these are the provisions. So, mainly that the state controller is having the power to exempt people from the application of this particular order. Secondly, that the state coal controller is also having the power to suspend, cancel, and revoke the licenses with the requirement of recording the reasons only, and such power can also be delegated to anyone by the state coal controller. So there was a person engaged in the business of coal. Now somehow his license was revoked, and therefore he challenges the revoking of the licenses on the ground that such a revoking of license is an infraction of their fundamental rights guaranteed under Article 14 and 19.